Correctional Services, Honorable Ronald Lamula. You are welcome, Minister. And I would like to welcome everybody on the virtual platform and those who are watching us from home. I would start with apologies. I have one apology, in fact, 3 apologies. One, the minister will be leaving early to attend an engagement with the president and the House of Traditional Leaders. We have the apology of Honorable Janji and Honorable Mola, who are attending Section 194 meeting. Are there any further apologies? Any other apologies? None. Can we now proceed? I would propose that we start with the adoption of the report so that those who would want to leave can be free to do so. Committee Secretary, can you flight the report? Can you flight the report? The report was circulated and it's taken as read. A report of the Portfolio Committee on Justice and Correctional Services on the Constitution 18th Amendment Bill, dated 17th March 2023. Are there any corrections on page 1? On page 2, is there Honorable Nivotruchen?
Good morning, Chairperson, and good morning to everybody on the platform. Chair, point 8, I'm not sure, on point 8, on the second line, it says the committee it's actually the third line. The committee notes that the use of sign language, it should be South African Sign Language.
Yes. Thank you very much.
The use of South African Sign Language, yes. Thank you very much, that's all.
Thank you very much. Is there a mover for the adoption of the report as corrected?
Honorable
Honorable Nivotruchen.
Honorable
Honorable Nivotruchen moves. Any seconder?
I second.
Morning, Chair. I second.
Honorable Yago seconds. Any objections? No objection. The report is agreed to. So we will await the programming committee to program the debate on the bill, which will be probably be next term when we come back from a constituency period, and we will do the necessary preparations when we come back from recess, that the bill will now be debated in the House. Thank you very much, members. Honorable Nivotruchen.
Chairperson, I would just like to really thank the Department of Justice and Correctional Services, all the staff there, everyone who has worked on this bill and did the briefing to the committee. Thank you to the Ministry for the support, and also thank you to this committee for passing the report. And I'd also like to thank all the deaf people and the hearing supporters who are all on the platform today. Thank you very much for your support.
Thank you very much. Also, I would like, on behalf of the committee, to thank the department for the support that they've given us. They've made our work very easy. It's one of those historic days when we'll be debating this bill before the House. We will be amending the Constitution, and it's one of those rare occasions where we will, as the country, be speaking as one in amending the Constitution to include sign language as the 12th South African official official language. Thank you very much, members, for all your help and your support, and your for also ensuring that we pass this amendment, and to the deaf community that have always been with us, dedicated, ensuring that this historic occasion they are part of. Thank you very much. Thank you, members. Let's now invite the Minister of Justice and Correctional Services. We are dealing with the certificate exemption in terms of the regulation, the RICA regulations. Welcome, Minister.
Yeah, thank you very much, Chairperson, for the opportunity for the department to come in and present on this certificate. I must state, Chairperson, that it has been a very long journey for the department up until we arrive here in terms of the interception of communications part, which is an indispensable tool for law enforcement agencies to detect, prevent, and investigate criminal conduct. The interception of direct communication and electronic communications and the provisions of communications-related information are regulated by RICA. The RICA, amongst others, prohibit the unauthorized interception of communication and provisions of communication-related information, authorize and regulate the interception of communication in emergency situations without direction, provide for application for and the issuing of directions authorizing the interception of communication and obtaining of communications-related information, and enter warrants for the placing and maintenance and removal of interception. It also provides for exemptions, which is what we are dealing with in terms of the certificate, which the South African police have to apply to the Minister of Justice and other relevant authorities, who must then get consent from my colleagues at Defense and other relevant departments affected, which Ms. Pillay will go into detail. So it has been a journey because upon many years of attempt to get this consent from other departments, issues were always raised, and as a result, the exemption certificate could not be submitted to Parliament, and this was to the detriment of the operations and the work of the South African police. So we are here today to present the exemption certificate to Parliament, and to also state the processes were followed, the laws and all the requirements that we had to adhere to. As the chairperson said in the introduction, I have a meeting now with the House of Traditional Leaders, and I would have loved to stay and listen to comments and up until to the end, but I would request that at around 10 to 10, I'm allowed to then exit to that meeting. But I will, at this stage, introduce the DDG legislative branch in the Department of Justice to present the exemption certificate in detail for the benefit and for further processing by the committee. Thank you very much, Chairperson, for this opportunity.
Thank you very much, Minister. Can we allow the DDG to make a presentation? as we have already noted all the apologies, even the minister's apology, he be allowed to leave at 10 to 10 to attend to the House of Traditional Leaders. Can I now hand over to the DDG, Ms. Pillay?
Good morning, Chairperson, and good morning to all the members. And thank you to the Minister for the brief background, for introducing the topic. And Chairperson, may I say that the presentation is slightly long with a lot of detail, but we felt it necessary to provide all this information to the committee members because it's useful and it gives a proper background of what the intention is behind applying for the exemption. Chairperson, if I may proceed, the interception of communications. I see we've moved on to slide number 2.
I'm sorry, Chair. Chair, I think Ms. Pillay has been kicked out by the system. I will try and establish communication with her.
Released from the meeting. Sia, will you be able to share the presentation to make it easier for me to navigate the, if I get thrown out again?
Ms. Pillay, are you going to share?
Yeah.
Okay,
my apologies for that, Chairperson. It's because we have connectivity issues, it's difficult to share, and if there's a problem with the connection, then I have to, it just takes longer to join again. My apologies, Chairperson. So I'm back on slide 1, and let me start again by saying the interception of communication is an indispensable tool for law enforcement agencies to detect, prevent, and investigate criminal conduct. The interception of direct communications and electronic communications and the provision of communication-related information are regulated by the Regulation of Interception and Communications Act of 2000, known as the RICA. The RICA, among others, prohibits the unauthorized interception of communications and provision of communication-related information. It authorizes and regulates the interception of communications in emergency situations without a direction. It provides for applications for and the issuing of directions authorizing the interception of communications and obtaining communications-related information, and entry warrants for the placing, maintenance, and removal of interception devices. RICA also obliges electronic communication service providers to provide an electronic communication service that is interceptable, to store communication-related information, to record and store customer information, and provide interception assistance. It also provides for the following interception methodologies. And ECSP activates a technical interception measure on its electronic communications network, or ECN, which duplicates and routes the electronic communications to the interception center, where it is stored for collection by the law enforcement agencies. An interception device, which must be provided by a law enforcement agency, is connected to the ECN of an ISP who is exempted in terms of Section 46 to intercept electronic communications. ISP is an internet service provider. An interception device is used to intercept electronic communications that is transmitted by an ECSP, and an interception device is used to intercept a direct communication at a specific place. RICA prohibits the unauthorized disclosure of any information which a person obtained in the exercising of any powers or the performance of any duties in terms of the RICA, and it prohibits the manufacturing, assembling, possession, selling, purchasing, or advertising of listed equipment, which is interception devices, by any person who is not authorized to do so in terms of a certificate of exemption. RICA further provides for the appointment of a retired judge who must consider applications for the issuing of directions or entry warrants and directives to be issued by the judge to supplement the procedure for making applications for the issuing of directions or entry warrants. I'm moving on to slide 5, which deals with listed equipment, which is contained in paragraph 3 of the explanatory memorandum. An interception device is defined in section 1, subsection 1 of the RICA as any electronic, mechanical, or other instrument, device, equipment, or apparatus which is used or can be used, whether by itself or in combination with any other instrument, device, equipment, or apparatus to intercept any communication. Section 44 of the RICA provides that a cabinet member responsible for the administration of justice, the minister, must by notice in the Gazette declare any electronic, electromagnetic, acoustic, mechanical, or other instrument, device, or equipment, the design of which renders it primarily useful for purposes of the interception of communications under the conditions or circumstances specified in the notice to be listed equipment. In terms of section 1, subsection 1 of RICA, listed equipment also includes any component of such equipment. In terms of government notice, R1263 of 29 December 2005, referred to as the notice, the minister declared the instruments, devices, and equipment discussed in paragraph 2.5 under the circumstances or under the conditions or circumstances discussed in paragraph 2.6 below to be listed equipment. And listed equipment is any instrument, device, or equipment which is capable of being used to A, access, record, monitor, or retrieve communications from a computer without the permission of the author of the communication, including but not limited to keystroke recorders and software. Sub B, record, monitor, or listen to a communication including but not limited to telephone wiretaps, long-range electronic audio amplified microphones, miniature laser audio transmitters, miniature radio frequency audio transmitters, cellular phone intercepting devices, and miniature sound recording devices. C, to visually record, monitor, or observe a communication, including but not limited to miniature video cameras, miniature cameras, and night vision apparatus. And D, determine or monitor the geographical location of a person, vehicle, or object. The conditions and circumstances. To manufacture, assemble, possess, sell, or advertise any of these instruments, devices, or equipment in paragraph 2.5 above with the intention to use it, whether by itself or in combination with any other instrument, device, equipment, or apparatus for the purposes of unlawful interception of communications of section in contravention of section 49 of the RICA. Subject to subparagraph A, any instrument, device, or equipment, or any component thereof, which is used in the ordinary course of an electronic communication service provider and which is used by an electronic communication service provider in the ordinary course of his business, is excluded from the operation of section 44(1)(a) of the RICA. 2.7, section 45(1) prohibits the manufacturing, assembling, possession, selling, purchasing, or advertising of any listed equipment. Paragraph 2.8, section 45(2) prohibits the prohibition, provides that the prohibition in section 45(1) does not apply to any electronic communication service provider, law enforcement agency, or person who manufactures, assembles, possesses, sells, purchases, or advertises listed equipment under the authority of a certificate of exemption that was issued to them for that purpose by the minister under section 46 of the RICA. In terms of section 46(1)(a), the minister may, upon application and in consultation with the relevant ministers, the cabinet members responsible for communications and digital technologies, defense, state security, and policing, exempt any person, a concept which is not defined in the Act, from one or all of the prohibited acts referred to in section 45(1), or B, a law enforcement agency from the prohibited acts of possessing and purchasing listed equipment referred to in section 45 for such period and on such conditions as the minister determines. Chairperson, this is the crux of the application that is serving before this committee today. Paragraph 2.10, the minister may only grant an exemption to a person or law enforcement agency on the basis of criteria provided for in section 46(2), and this aspect is discussed in paragraph 4 below. Section 46(3)(a) provides that an exemption under section 46(1)(a) must be granted by issuing to the person or law enforcement agency concerned a certificate of exemption in which its name and the scope, period, and conditions of the exemption are specified. In terms of section 46(3)(b), a certificate of exemption issued under section 46(3)(a) must be published in the Gazette and becomes valid upon the date of such publication. In terms of section 46(4) of the RICA, the minister must, before he publishes a certificate of exemption in the Gazette under section 46(3), table such certificate in the National Assembly for approval. That is in terms of section 46(4)(a). The National Assembly may reject a certificate tabled in terms of paragraph A within 2 months after it has been tabled. If the National Assembly does not reject a certificate as contemplated in subparagraph B, the certificate will be deemed to have been approved by the National Assembly, and the minister must publish the notice in the Gazette. If the National Assembly rejects such a certificate in paragraph B, the minister may table an amended certificate in the National Assembly. Moving on to the application from SAPS on slide 11. Although the SAPS applied in 2010, 2011, and 2012 to be exempted in terms of section 46(1)(a), these applications were unsuccessful since the approval of some of the relevant ministers could not be obtained. The current application is motivated as follows. The Intelligence Division of the SAPS is in possession of listed equipment. It designs, builds, and manufactures some categories of listed equipment. It uses listed equipment to investigate, combat, and prevent serious criminal activities. The following control measures are in place to regulate the use of listed equipment. Access to the listed equipment is restricted. Registers are kept for the use of the listed equipment. A single nodal point at the Crime Intelligence Head Office exercises control over the listed equipment. The head, Operational Intelligence Support, must authorize the use and activation of listed equipment. Only authorized members of the Intelligence Division of the SAPS have access to and can use the listed equipment. Listed equipment is only used to intercept communications if it is authorized by the designated judge. The exemption is in the public interest since the possession and use of listed equipment is necessary to investigate, combat, and prevent serious criminal activities. The SAPS must, in terms of section 46(1)(a)(3), be exempted for a period of 5 years from the prohibited acts of possessing and purchasing of instruments which are used to determine the geographical location of persons, vehicles, or objects, also known as the grabber device or IMSI catches, including other listed equipment specified in the notice and on condition that the use of the equipment is subject to compliance with the provisions of the RICA. Although the application for exemption refers to section 46(1)(a)(3) as the applicable provision to the application, it is submitted that an application in respect of the manufacturing and assembling of listed equipment as discussed in paragraph 3(2)(a) sub 2 above must be dealt with in terms of section 46(1)(a)(2) of the RICA. In compliance with the consultation requirement in section 46(1)(a), the minister and the relevant ministers indicated that they support the SAPS application for exemption and approve the certificate of exemption. The criteria for exemption, paragraph 6 of the explanatory memo, which sets out a memorandum which sets out the detail of this paragraph. Section 46(2) provides that the minister may only grant an exemption to a person from the prohibited acts referred to in section 45(1) if he is satisfied the purpose for which the listed equipment will be manufactured, assembled, possessed, sold, purchased, or advertised is reasonably necessary. And sub 2, such exemption is in the public interest or special circumstances exist which justify such exemption, or a law enforcement agency from the prohibited acts of possessing and purchasing referred to in section 45(1), if he is satisfied such exemption is in the public interest or special circumstances exist would justify such exemption. On the criteria for exemption, it is submitted that the reference to any other person in section 46(1)(a)(2) must be construed to include a law enforcement agency. For the reasons discussed in paragraph 4.6 of the explanatory memorandum, the application for a blanket exemption in respect of all listed equipment specified in the notice could not be accommodated. The criteria that must be considered to exempt the SAPS from the acts of A, possessing and purchasing listed equipment are that such exemption is in the public interest or special circumstances exist which justify such exemption. As I explained in the previous slide, section 46(1)(a)(3) and 2C and sub D. And manufacturing and assembling listed equipment are that the purpose for which the listed equipment will be manufactured, assembled is reasonably necessary, and such exemption is in the public interest. Or 2, special circumstances exist to justify such exemption, section 46(1)(a)(2) and 2B, C, and D. The requirements for exemption in the public interest, special circumstances which exist, justify the exemption, and purpose for which listed equipment will be manufactured or assembled is reasonably necessary are discussed further in paragraph 6.2 of the explanatory memorandum. It is submitted that an exemption from the prohibited acts of possessing, purchasing, manufacturing, and assembling of hardware, keystroke recorders, telephone wiretaps, long-range electronic amplified microphones, laser interception devices, miniature radio frequency transmitters, miniature recording devices, miniature video audio cameras, miniature cameras, night vision and thermal imaging apparatus and monitoring equipment can be justified on the basis that such exemption is in the public interest for the following reasons. It is in the public interest to investigate serious crimes. The RICA specifically authorizes the use of listed equipment. Electronic communications are increasingly being used to plan, facilitate, and commit serious offenses. The equipment are designed and used to effect targeted interceptions only. There is no confirmed history or pattern of abuse of the equipment. The interception of direct communications and monitoring of an interception subject can only take place by means of interception or monitoring devices. Measures are in place within the SAPs to prevent abuse of the equipment. As part of the conditions of the exemption, the draft certificate of exemption provides for oversight and control mechanisms relating to storage, assignment for use, possession, and the use of the listed equipment. The unauthorized disclosure of the interception result obtained through the use of equipment is criminalized in terms of section 42(1). The Inspector General of Intelligence is obliged to monitor compliance with the RICA, which includes the use and disclosure of the interception result and compliance with the conditions of the draft certificate of exemption. Transparency and public reporting on listed equipment possessed by law enforcement are addressed in terms of section 46, which requires publication of a certificate of exemption in the Gazette. The RICA substantially complies with international applicable standards to regulate the interception of communications, and the police and intelligence agencies in foreign constitutional jurisdictions use the equipment to intercept communications. Since an exemption from the prohibited acts of possessing and purchasing of the listed equipment can be justified on the basis that such exemption is in the public interest, it is not necessary to consider the further requirement of special circumstances exist to justify such exemption. The further requirement for an exemption from the prohibition of manufacturing and assembling of the listed equipment in paragraph 4.6 is that the purpose for which the equipment will be manufactured or assembled is reasonably necessary. The purpose of the manufacture or assembling of listed equipment relates directly to the operational requirements of the SAPs to prevent, combat, and investigate serious crime by means of the use of listed equipment in the context of the RICA. Although the listed equipment in paragraph 4.6 may be acquired as off-the-shelf items, there are various instances where this equipment may need to be modified or manufactured to suit the circumstances of a particular investigation. Since an exemption from the prohibited acts of manufacturing and assembling of the listed equipment in paragraph 4.6 can be justified on the basis that such exemption is in the public interest and that the purpose for which the listed equipment will be manufactured and assembled is reasonably necessary, it is not necessary to consider the further requirement of special circumstances exist to justify such exemption. In light of the above, it is recommended that SAPs be exempted from the prohibited acts of possessing, purchasing, manufacturing, and assembling of the listed equipment referred to in paragraph 4.6. Since listed equipment is defined to also include any component of such equipment, it is recommended that SAPs also be exempted from the prohibited acts of possessing, purchasing, manufacturing, and assembling of equipment that is reasonably necessary to be used with the listed equipment referred to in paragraph 4.6. Any component of or software necessary for the operation of the listed equipment referred to in paragraph 4.6 and the equipment in subparagraph A that is reasonably necessary to be used therewith. Paragraph 4.10 of the presentation, IMSI catchers. The IMSI catcher is a device for the interception of cellular communications. According to the application, the IMSI catchers in question cannot intercept call content by design. The specific range and capabilities of IMSI catchers depend on the model being used. Further information regarding the capabilities of the IMSI catchers has not been made available for evaluation. IMSI catchers intercepts not only communication of an interception subject, but also other communications within a specific area. IMSI catchers are dual-use items in terms of the Varsana arrangement on export controls for conventional arms and dual-use goods and technologies. This is an indication that this category of equipment has a high potential of causing detriment. Notwithstanding the aforementioned concerns, an exemption from the prohibited acts of possessing and purchasing IMSI catchers can, on similar grounds referred to in paragraph 4.6, be justified as an exemption in the public interest. If exemption is considered not to be in the public interest, it may nevertheless be justified on the ground that special circumstances exist would justify such exemption. These special circumstances include the following. If the operational needs of the SAPs are taken into account, where immediate actions are required in life and limb situations such as the kidnapping of a person, the RICA process may be inadequate insofar as it relates to the timeous and ongoing furnishing of the information to the SAPs during hot pursuit operations. The Interception Center, as in the recent past, experienced technical difficulties which adversely impacted on the capabilities of the SAPs to obtain intercepted communications. Triangular determination of location is retrospective in nature, and there is a substantial delay before it is received. The generality of the information that is intercepted when used to determine location, namely communications related information, cannot be regarded as an infringement of privacy that is on par with the interception of call content. An exemption from the prohibition of manufacturing of IMSI catchers was not considered as the SAPs does not have the expertise or capacity to manufacture the IMSI catchers. The assembling of IMSI captures in the sense of putting together the different components of such a device or installing software may well be conducted by the SAPs, and an exemption on the grounds provided in section 46(2)(b) and C may be considered. In light of the above, it is recommended that the SAPs be exempted from the prohibited acts of possessing, purchasing, and assembling of IMSI catchers subject to the conditions which the minister may determine in terms of section 46(1) of the RICA. Specific interception capability conditions that must be imposed on the IMSI catchers are that the hardware and software configurations of the device must not enable the device to intercept call content and limit the interception capabilities of the device to the interception of call-related information. Since listed equipment is defined to also include any component of such, it is recommended that the SAPs also be exempted from the prohibited acts of possessing, purchasing, and assembling of equipment that is reasonably necessary to be used with the IMSI catcher, and any component or software necessary for the operation of the IMSI catcher and equipment that is reasonably necessary to be used therewith. Technologies to intercept communication from computers. The application for a blanket exemption extends to listed equipment which is capable of being used to access, record, monitor, or retrieve communications from a computer without specifically identifying the type of software or equipment in respect of which an exemption is requested. These technologies vary from targeted interception of electromagnetic signals between two computers to complex software which is surreptitiously installed on a computer device through hacking to mine data, including interception of communications, to probes which may be installed on the fiber optic submarine cables that connect South Africa with the rest of the world. This exemption request in paragraph 411.1 was unsuccessful. In terms of section 46(3)(a), an exemption under subsection 46(1)(a) must be granted by issuing to the law enforcement agency concerned a certificate of exemption in which the scope, period, and conditions of the exemptions are specified. The scope of the exemption in respect of the different categories of listed equipment is discussed in paragraph 4.9 and 4.10 J to L above. Due to the fact that the equipment may be abused, the use and available must be strictly controlled. It is therefore proposed that the exemption of the SAPs from the prohibited acts referred to in section 45(1) be made subject to the conditions discussed in the paragraphs below. The listed equipment may only be possessed, purchased, manufactured, assembled, and used to the extent authorized by the RICA. The National Commissioner of Police must personally authorize the purchasing of IMSI catchers, any equipment reasonably necessary to be used with such IMSI catchers, and any software to be installed on such IMSI catchers or equipment reasonably necessary to be used with such IMSI catchers. All listed equipment and any equipment reasonably necessary to be used with such equipment, with such listed equipment must be marked with a non-alterable identification number. The National Commissioner must designate a divisional commissioner, and the head of the DPCI must designate a major general, a designated member at national level, who will be responsible and accountable for the purchasing, manufacturing, and assembling of listed equipment, access control to listed equipment, the issuing of written authorization for the use of listed equipment, the keeping of consolidated records of the use of listed equipment, oversight over the use of listed equipment, and compliance with the conditions determined in the certificate of exemption. The designated member must, in respect of any listed equipment in possession of the SAPS or DPCI, obtain and keep a certificate in which the interception capabilities of the listed equipment are specified, and make such a certificate available to the Inspector General or retired judge referred to in section 17L of the South African Police Service, the retired judge. The designated member must, at the end of each quarter of a financial year, cause an inspection to be performed at the places where the listed equipment is kept in order to verify compliance with the conditions of the certificate of exemption. and submit a report to the National Commissioner and the National Head DPCI as the case may be, which must contain the following information: the number of authorizations that have been issued for the use of listed equipment during the period, the categories of listed equipment that were used, the dates on which they were used and the purposes for which they were used, the dates on which the secure places where the listed equipment is kept were inspected, and the particulars of the member who carried out the inspection, any non-compliance with the conditions of the certificate of exemption, and any loss or unauthorized use of listed equipment which came to his or her attention. At the end of each financial year, submit an inventory to the National Commissioner and the National Head of DPCI, as the case may be, of all listed equipment in possession of the SAPS and the DPCI at the end of that financial year. Secure storing, access control, record keeping and handling of conditions are imposed in respect of the listed equipment. The following conditions were determined where listed equipment is used to intercept communications in terms of sections 4, sub 2, 5, sub 2, and 7 of the RICA. A, the designated member must authorize the use of listed equipment. B, the authorized member who use the listed equipment to intercept communications must submit a written report under oath or affirmation to the designated member, which must contain the following information: the type of listed equipment used, the date and time of activation and deactivation of the listed equipment, the type of communications that were intercepted, the nature and location of the facilities from which or the place at which the communications were intercepted, the identity of any person, if known, whose communications were intercepted, and all authorized persons who participated in the interception of communications by means of listed equipment under the physical control, the date, time, and place and particulars of the authorized persons who respectively handed over and received the listed equipment, and the functional status of the listed equipment. And 2, whether or not the communications related to a ground contemplated in section 16(5)(a) of the RICA. C, must be accompanied by a copy of the written authorization in subparagraph A and the internal control document that will indicate the time and date of receipt and return of the interception device, and must, in addition to the documents referred to in section 7.4, submit to the designated judge an affidavit with the information in subparagraph B, which must be accompanied by documentation in subparagraph C. The following conditions are determined where listed equipment is to be used in interception in terms of directions in terms of section 16, 17, or 18. Application for direction must specify the category of listed equipment that will be used to intercept the communications, indicate the identification number of the listed equipment, and all persons who will use the listed equipment or subject to the issuing of an entry warrant in terms of section 22(3), install and maintain the listed equipment at the premises to intercept the communications. The authorized persons referred to in subparagraph A3 must, within 5 days of the expiry of a direction, submit to the designated judge an affidavit which must contain the information referred to in paragraph 5(11)(b) and a copy of the internal control document that will indicate the time and date of the National Commissioner, and the head of the DPCI must immediately, in writing, report any loss or unauthorized use of any listed equipment reported to them in terms of paragraph 5.9 above to the Minister of Police and the Inspector General or the retired judge, as the case may be. The Minister of Police must, not later than 3 months after the end of a financial year, submit an inventory to the chairperson of the Joint Standing Committee on Intelligence, the Inspector General, and the retired judge of all listed equipment in possession of the SAPS as at the end of that financial year. And B, table a report in Parliament containing the following information: the number of authorizations that were issued for the use of listed equipment and the purposes for which those authorizations were issued, the categories of listed equipment that were used in respect of these authorizations, any unauthorized use of listed equipment which came to his attention, and steps that were taken in response thereto. The last slide, Chairperson. The SAPS is exempted for a period of 5 years from the prohibited acts of possessing, purchasing, manufacturing, and assembling of the listed equipment specified in item 1 of part 3 of the certificate, and possessing, purchasing, and assembling of the listed equipment specified in item 2 of part 3 of the certificate. Thank you, Chairperson. That is the presentation.
Thank you very much, DDG Pillay. Members, any questions or comments? Honorable Steve Swartz, followed by Honorable Engelbrecht.
No, thank you, Chair. I'll turn off the camera just for connectivity issues. Chair, I appreciate the lengthy explanation. I do understand the need operationally for the police and the need for this exemption, but I do have a number of questions, given that this is a difficult area for us. We don't, as this committee, have expert oversight, but we understand the RICA Act has come to us, well, gives us that jurisdiction, gives the minister that jurisdiction. And I think just at the outset, Chair, I would need to know what is the timeline, given there's a 2-month is referred to. So where are we in that 2-month period? Is there a deeming provision? Because this is a very far-reaching aspect exemption. As I indicated, I understand the operational needs, but I would be interested to know, Chair, or maybe we need to deliberate on this, to what degree are we expected to exercise oversight when we don't actually know how all these items work, the listed items from an operational perspective, and to what degree should we be consulting with the portfolio committee on police. Now, Chair, one of the concerns, given that one wants to strike the balance and given the need that we understand the high crime rate in South Africa, we understand sometimes the urgency when it comes with kidnapping matters for the usage of the listed items. But I think it's not correct for the department to say there's a history of no abuses or that slide, because we know that in September 2021, the designated intercepting judge, Judge Bess Nkabendi, she, in her report to Parliament, she lamented, quote, the unceasing unlawful interception of communications of private and public officials, and how agencies bypassed her office and unlawfully intercepted communications. And she also said the state authorities lying to get interceptions approved was a shocking reality. So one's got to consider these aspects when we consider these exemptions. One also has to consider the abuse that took place under General Ndluli, crime intelligence, that over a period of time, and even last year when the former Police Commissioner Khamatsu Pashlani was arrested, where there are allegations of corrupt practices, wiping call records, failing to report deviations, etc. And this could be linked to a systemic, at that time, abuses in crime intelligence. We don't know what the situation is now. One hopes it has been improved substantially. But at that time, it was alleged that senior police officials procured software that would make it impossible for investigators to get their phone call records. So this is all clearly the department. Advocate Pillay will say, but that's illegal in any case. Yes, that's reality. But to what degree was that happening? And to what degree was prosecutions taking place as a result of non-compliance with RICA? Chairperson, so I'm in a bit of a dilemma. Maybe I need to just consider the memorandum a bit more in detail, but I'd also like to know, how has SAPS operated without the exemption? The one slide indicates it was applied for in 2010, 2011, 2012. The authorities were not granted by the ministers. We understand this present request, this application was applied for in July 2019. We're now sitting in 2023. What is the reason for the delays in bringing it to us? And I think it's important to have a balanced approach to ask the question, what impact does the delays in these approval have on the operational efficacy of the police? And lastly, Chair, the impact of the RICA Act being found to be unconstitutional in the Amabungani Center for Investigative Journalists, the Sol case, where the court found it is unconstitutional to the extent that it fails adequately to prescribe procedures to ensure that data obtained pursuant to the interception is not managed lawfully and not used or interfered with unlawfully. Now that clearly indicates that there is a problem. And so we need to balance all these interests as we approach this, Chair. Thank you so much.
Thank you, Honorable Engelbrecht.
Thank you, Mr. Chair. I just want to know the exemption. Obviously, I don't think that we should even consider giving retrospective approval on a retrospective basis, because I get this, I just want to know, has this got anything to do with the 2017 grabber incident, where the current Minister of Police and the former Commissioner of Police were involved in? Because there are very serious allegations that's been made relating to this kind of devices that's that has been used illegally by our law enforcement agencies. Because in this presentation that we just saw under point 2.1.2, no, 2.12, sorry, you know, it becomes valid from the date that it would be gazetted going forward. No retrospective indemnification of stuff that happened years back. Because I think those things needs to be, those allegations needs to be investigated. I know there was an attempt by IPID, but it was an unsuccessful attempt. So there's very, very serious allegations made, and there's other documentation that is available. For instance, the Deputy National Commissioner's protective disclosure, you know, there's some stuff there that needs to be considered, as well as a police member that was present and part of this during the purchase of said devices back then. So, and we know the media has, they have this information. And I just think to try to unscramble an already scrambled egg would not be in our interest whatsoever. Thank you.
Thank you. Thank you, Honorable Engelbrecht. Honorable Nieuwhof, Trochen.
Thank you, Chairperson, and thank you for the briefing, Ms. Pillay. Chairperson, this is a very, very new thing to me. So I'm really trying to understand this. I've never had a presentation on this kind of thing previously, but as I was looking, I want to know, because it came up in the newspapers and on WhatsApp groups with regards to drones. Now, who is responsible for allowing drones to move around? Because at the airport, there's been complaints that drones have been flying around in the way of planes when they land or take off. Now, in WhatsApp groups, people are wondering why there are drones. Are they intercepting our privacy, etc.? So I was just curious who controls drones. Does this also include that? Will they be exempted from that as well? So just something that I was curious about. And some of the other members have already asked this, but how do we, especially we as a committee, how do we know that whatever exemption, whatever is exempted or not exempted in terms of technology is not abused when it is used? Because most of the technologies is done by another department. Okay, so it's the SAPs. So the portfolio committee on SAPs, they will get the report. So do we as justice, we are asked to approve the exemption, but we might have never seen a report in relation to whatever technologies is being exempted or not exempted. It doesn't really come to this committee. So I'm just trying to understand, we are asked to approve this, but we don't get a report. And then the operations is done by SAP. So I just needed more clarity on that. I'd appreciate. Thank you, Chair.
Thank you, Honorable Nivot Duchan. I think some of the issues might be challenges with the Principal Act, which was passed by this committee in 2000. Not generally, I think the regulations are flowing from the Principal Act. Maybe what we should also be looking at is to relook at the Principal Act. Maybe we might propose to Parliament, to the National Assembly to look at the Principal Act, so that portfolio committees that would have the necessary oversight and expertise in the near future are the ones that would recommend with authority to the National Assembly whether regulations would need to be accepted or not be accepted. That is, the exemptions would need to be passed or not be passed. But those are the problems that I think are with the Principal Act that might need to be relooked at. DDG Pillay?
Thank you, Chairperson. May I just mention that members of the South African Police Service are online, and I wonder if you would like us to give them an opportunity to come in first to respond to some of the issues that have been raised, and then I can come in, Chairperson, if that's okay.
That's fine. Who would be answering from the SAPS delegation?
Okay, Brigadier van Kraan, can you please refer to the relevant person?
Thank you, Honorable Chairperson and Honorable Members. I'm Brigadier Frans van Kraan of the SAPS Legal Services. With me on this platform is Major General Lushaba of Crime Intelligence. I can speak about the legal issues and the Honorable Member who remarked about drones. Drones is not part of this request for exemption. It's regulated by the civil aviation legislation and the control measures there. And the police also have a number of instructions and applicable national instructions that regulate the use of drones, etc., etc. So drones is not part of the picture. All that I can say to the Honorable Chairperson and the members is that, yes, we are in possession of this equipment. We are trying to comply with the legislation as law enforcement agency. This is why we submitted the request for exemption, which, as the Honorable Chairperson and members will know, has a very, very long history where we were unsuccessful. So we were really pushing to make our actions lawful, to ensure the public and the Honorable Committee that we are our endeavor is to comply with the law. This is why we do it. But this is really our intention to make it lawful. Our challenge is, and there's information to this court, that private persons in this country is abusing the process, also have this equipment in their possession. And we as law enforcement is, as a matter of fact, challenged by the current legislation, because the private sector who does this illegally goes so unnoticed without consequences. And we just, as law enforcement agency of this government, want to ensure that our actions are lawful. I don't know whether Major General Lushaba want to comment as custodian of these equipment in CI. Thank you, Honorable Chairperson.
Thank you, Brigadier. General Lushaba.
Good morning, Honorable Chair. And the members of the committee, thank you. My apologies, I joined the meeting late, but I did hear some of the questions. At first, whether the equipment in question, is it the equipment that was procured in 2017? And our response will be, yes, the equipment was procured in 2017, and it has never been used since then. It has been in our warehouse storeroom, waiting for this process and the blessings of the Honorable Committee before we can deploy the equipment. Before then, there's a long history of this equipment, as it was explained before. Some of this equipment used to be with the Scorpions before, and then from there it was handed over to the Hawks, and then since it was then within the SAPS, a decision was taken that crime intelligence must be the custodian. All the equipment must be under the control and use from the division crime intelligence, so that there will be better control. And all the equipment that were there, they were used without these exemption certificates before, but those equipment, they have since been boarded. They are no longer usable. So now we are waiting of these new equipment bought in 2017 before we will be able to do our operations. And yes, it has been difficult. We have lost or been unsuccessful in a number of cases where we should have done better if we were able to deploy this equipment. There are latest cases where we know the suspect, we know more or less the vicinity where they are, but we will not get to them because we cannot deploy the equipment. So the authority or the blessing to start making use of this equipment, it will have a massive contribution to fight crime fighting initiative. And we hope the Honorable Committee will bless. And the cases of abuse, whenever they are brought to the attention of the National Commissioner and the South African Police Service, yes, they get investigated to validate whether indeed there will be positive elements of abuse, or to refute those. The most recent one were the allegations that there were equipment that were deployed, something that was in the public domain around the issue of the Pala farm. And it was indeed investigated. That was last year. But it was negative. None of our officials were involved. So moving forward, we listen to the control measures that were presented here, and on our side, we will give assurance that we will comply, and we'll make sure that all those the quarterly reports that we must provide to the oversight will indeed provide those reports for the oversight to come and do regular inspections, and then ensure that there's no misuse or abuse of the equipment. Chair, if I missed any questions, like I indicated, I joined at a later stage, and I struggled with the connection for some time before I could settle down. If I missed on some of the questions, I can come back on your request, Honorable Chair. Thank you.
Were there any investigations that were positive? And if yes, what was done about those positive investigations?
Thank you, Honorable Chair. For now, I'm not aware of any investigations that were positive, but we can go and then verify to make sure that we don't miss anything. Myself, I'm not that old within the division. I'm part of the officials that have been recently appointed to come and ensure stability within the division. So we can go back and check, Honorable Chair, and then we can finish the committee with that information at a later stage. Thank you, Chair.
Thank you very much, Honorable Swart.
Thank you, Chair, and thank you to the General. And I really want to express our appreciation for the work that the police do under very difficult conditions. And so please, we appreciate when we ask these questions, that is to give us clarity. We don't want to do anything that sacrifices the operationality of the police. But at the same time, it's, as I pointed out, there are a number of allegations of abuse that has taken place. And I think what I would like a comment about is the comments made by the designated judge in Kabinde about the ongoing issues of abuse, where in her report to Parliament. And that obviously we've got to take note of, as well as the Constitutional Court's finding when it came to illegal surveillance. Now, I appreciate your answer. You say that if it's illegal, then it will be investigated. But the challenge is that it seems to be in the ranks of the police itself. And that led to the Constitutional Court finding that the safe custody and of data and those provisions of RICA were unconstitutional, which is very far-reaching. And when it came to what one presumes is illegal surveillance of the Amabungani Center for Investigative Journalism and Mr. Sam Sol, that was 2 years ago, and we'll be dealing, Chair, with that. We've got to deal with that amendment, and we might need to look more broadly at the act, as you indicated, given the operational concerns. But I'd also like to ask whether when the memorandum, maybe the DG Pillay can also respond to this, is the comments that were received when the notice for the exemption was gazetted. We would like to have a look at that as well. So Chair, again, to appreciate what the police do, but at the same time, we are required to exercise oversight over an area which we don't have very much knowledge. And I think the concern is on the 24th of September 2022, the former acting National Police Commissioner, as I indicated earlier, Komatsu Paslana, was taken into custody along with 3 other serving crime intelligence officers. And we appreciate that there seems to be new officers there now, but I hope the General understands why we are asking these questions from an oversight perspective. Thank you, Chair.
Thank you very much. Brigadier van Gaan.
Honorable Chair, thank you very much for the opportunity. Just for the sake of the Honorable Member Swart, the Amabungwane judgment had a bigger impact on the State Security Agency than on the SAPS. Because the big issue in the Amabungwane judgment was the so-called bulk interceptions that our RICA law does not provide for. We're not speaking here about bulk interceptions. We're really speaking here locating a phone where a crime is being planned or committed, for instance, in a terrorism incident or in a kidnapping situation, as by way of an example. So the bulk interception, which was the main issue in Amabungwane, impacted on our sister department, the State Security Agency. There were certain control measures proposed and made an obligation on the SAPS in the Amabungwane judgment as far as control measures are concerned, which I can state categorically that we have implemented to give effect to that judgment. So I just want to put that on record through you, Honorable Chair, that we have worked on the consequences of the Amabungwane judgment. And as I said, it impacted us lesser than the State Security Agency because bulk interception is not something that has ever been done or is the mandate of the police service. It is in any case in contravention of the law. Thank you, Chairperson.
Thank you very much. And I can confirm that that bill is coming to us. The RICA amendment is coming to us. So we will have to look at that together with the relevant portfolio committees. Honorable Engelbrecht.
Thank you, Mr. Chair. I want to thank General Lushaba for his answers. However, the allegations of illegality doesn't lie in the use of it. It lies in the purchase of said equipment without the exemption certificate, which is obviously problematic. And I want to know what's going to happen now. Because that's it is obviously a problem that a law enforcement agency that's supposed to uphold the law itself is in contravention of the law. And then just the one question, this exemption certificate, once it is approved, I just want to confirm that it would not be retrospectively. It would be from the date that it has been approved by Parliament.
Are you done, Honorable Engelbrecht?
I'm done. Thank you.
Thank you very much. Brigadier van Gaan.
Chairperson, through you, Honorable Chairperson and Honorable Member, the RICA Act is very clear that this thing cannot be done retrospectively. The process for approval is prescribed in the current provisions of RICA, and it's clear that it doesn't make provision for retrospective approval. It's only once this process is done through the Honorable Committee and publication in the Government Gazette that the exemption will apply. Thank you, Chairperson.
Thank you very much. What about the patches? Brigadier van Gaan, I think the question from Honorable Engelbrecht was in two parts. The first part was the issue of retrospectivity, and the second part was the issue of the patches.
Thank you, Honorable Chair. Can I come in and talk about the patches?
Okay, General Shaba.
Thank you, Chair. Honorable Chair and honorable members, with regard to the purchase consequence management, it was implemented by the former National Commissioner. The matter was investigated, and we can confirm that there is a case that is currently within the SSPC against the members who were involved with the purchase of the equipment. Though the complexities that were there as the members advance their statements or mitigating factors. One, as it was discussed before, this equipment, if you look at other law enforcement agencies, I think, and intelligence services, all of them, they are in possession of the same equipment, including other private security agencies. But from the SAPS, I think being the first applicant as well for this exemption certificate, there is action against those members who were involved with the purchase. Thank you, Honorable Chair.
Thank you very much. DDG Pillay.
Thank you, Chairperson. I think the questions have largely been answered by Major General Lushaba and Brigadier van Graan, and Brigadier van Graan has just reiterated that the application is not retrospective. It will apply from the date on which the Gazette is published. And I think the questions on the constitutionality of the issues have also been dealt with as the instances of abuse and the investigations that are ongoing. And Chairperson, I think on the side of the department supporting those comments that have been, the responses that have been made, and to motivate that this application be approved, I think in closing, the department would like to point out that I think it is a question of how we balance those concerns around abuse of the equipment. And we believe that the safeguards that have been proposed in our presentation are quite extensive to mitigate against the concerns that have been raised. And also, I think we must balance the issues around interception and issues of privacy and abuse of the law with the need to fight crime. And as we can see, we are facing increasing levels of organized crime, and this application is necessary for the South African Police Service to attend to its constitutional duties. Thank you, Chairperson. That is the aspect from the department that we wanted to raise. And if there's anything further, I will address the committee further.
Thank you very much. DDG Pillay, if this is not agreed to by Parliament, what damage will that have on the fight against crime, since we have not been having it anyway?
Thank you, Chairperson. Yes, I think that's one element that we have not addressed in the answers, and that was raised by the Honourable Member Swart, because it has taken so long. Chairperson, it is not for reason of not trying to get the exemption granted. There were numerous applications, a number of engagements. The Act, unfortunately, is worded in a manner that every minister must agree. So we would get agreement from one minister or an application from another minister, but one would say no, and that was because of issues around the mandates of specific departments or certain departments where there may have been an overlapping of the mandate, and there were challenges around that. And it's only for that reason that we could not get the application granted. And an application being submitted since 2010 to now, I would think as cause, I cannot provide any evidence, which maybe, I think the crime statistics will talk to that. While we cannot provide the evidence on what happened because we did not grant the exemption, or we did not get the exemption approved on time, that is a matter for evidence, and it's an evidence-based question, which I think SAPS, if required to provide that information, may be able to do so. However, I do want to reiterate what Major General Lushaba and Brigadier van Graan said. This application is in terms of the legislation, which is attempting to grant, to list the equipment and to give SAPS the legal basis upon which to manufacture, possess, and own and purchase this equipment going forward. And I think that is going to have the impact in terms of crime fighting and empowering the South African police. Chairperson, I hope I've answered that question.
Thank you very much, Honorable Swart, followed by Honorable Engelbach.
No, I really appreciate the engagement because it's helping us understand these quite complex issues. I appreciate the inputs from the General and from Advocate Pillay. Obviously, an issue that's been a lot in the media is the tragic murder of Lieutenant Colonel Charles Kinnear, which arose as a result of illegal surveillance by a private institution. And that does indicate that there seems to be rampant abuse of tracking through cell phones through private individuals. And I think the General made that point. The point I want to make is and I think the General has made that, Advocate Pillay has made that point, that this granting of this exemption would assist the police with dealing with illegality and illegal surveillance. And one's got to balance that operational benefit to the possible abuse, as I pointed out earlier. But I would like to just ask Advocate Pillay about comments received, whether we could obtain those comments that when the application for the exemption was gazetted. We particularly would like, and Chair, I'm not sure how the timeline that we've got, these are complex issues, but I appreciate what the SAPs want to do is they want to rectify an issue which has taken a long time. So we can't sit on this too long, given the fact that it's come many, many years and it's not our fault. But clearly, if we can assist in the fight of crime, one needs to do that. But I don't quite know what the committee is considering as far as timeline is concerned. Thank you, Chair.
Thank you very much, Honorable Engelbach.
Thank you, Mr. Chair. I do not wish to belabor this point. I just want clarity here. General Lushava said that the members involved in the purchase of said equipment are being investigated by the SSBC. Well, I just want to, for clarity's sake, know which criminal cases are being investigated and who is doing that investigation.
Thank you, Honorable Engelbach. I'm not sure whether are we not strangling on the oversight responsibility of the Portfolio Committee on Defense or on Police, but General Lushava, you may answer.
Thank you, Honorable Chair. The case that is before the SSBC, it is actually the internal departmental case. I can just verify on the criminal case. Like I said, these are the matters and investigations that started way back by the former National Commissioner before I came to the environment. But I'm aware of the case that is within the SSBC because it is sitting in the disciplinary register of the division. Thank you, Honorable Chair.
Thank you very much. The questions that were raised by Honorable Swart, Ms. Pillay.
Thank you, Chairperson. I will refer to slide 10 of the presentation. The minister must, before he publishes a certificate, table the certificate at the National Assembly. And as indicated, the ministers have now agreed. So when it gets to the National Assembly may reject a certificate tabled in terms of paragraph A within 2 months after it has been tabled. It was tabled last week, Friday, so the National Assembly has 2 months to reject it. If the National Assembly does not reject a certificate as contemplated in subparagraph B, the certificate will be deemed to have been approved by the National Assembly and the Minister must publish the notice in the Gazette. If the National Assembly rejects the certificate, the Minister may table an amended certificate, may table an amended certificate in terms of section 46(4)(c), and then we may publish. So those are the steps that we may take. And this is all in terms of section 46(4) of the Act.
But Advocate Pillay, that would be a deeming provision if after the speaker has referred the matter to us, we did not do anything, the National Assembly does not do anything, then after 60 days, it would be deemed to have been approved, and then thereafter, the minister within 30 days must gazette it. But now it was referred to us on Friday, we are dealing with it now. So if the National Assembly approves it, will the minister still need to gazette it thereafter? Then that is one question. Then the second question, are there any comments that are in your possession that you have that were made by members of the public?
No, Chairperson, we don't have any comments.
There are no comments.
No.
I think that is your answer, Honorable Swart. There are no comments that are before them because it has not yet been gazetted. Members, any further questions? Members, I would propose the following, that we do approve the certificate, but it's quite clear that the RICA Act needs to be re-looked at in its entirety, because the regulations that we are dealing with today, they are a secondary legislation flowing from the RICA Act. The fact that we must do this is referred to the Committee of Justice and Correctional Services is because the minister, in terms of the act, is the one that is meant to, in fact, is the one who signs before it comes to us. Those are the areas that we might need to look at. Maybe we can recommend when we are making our recommendations to Parliament that there are certain areas of the RICA Act that might need to be re-looked at, because we are approving as regulations where we do not really have oversight of. There might be a good reason even for that, because I think maybe what was in the mind of the legislatures at that time was to create checks and balances that you do not have. For instance, a situation where the police are making up an application, it's them that are going to use these equipments. It's the same portfolio committee that has got oversight over them. So those are the discussions that we might need to revisit and to check whether they are still applicable. And bearing in mind that this RICA Act was passed in 2000s, there have been a lot of developments, even in terms of technology, since it was passed. But my proposal, if there is no objection, is that we move towards agreeing that the certificates be, in fact, that the National Assembly agrees to these exemptions, and further work be done in terms of relooking at the Act and what can be improved going forward. Honorable Swart.
No, Chair, I'm in support of your approach. I understand the operational needs. We will just need to make sure that safeguards are enforced. I think that's very important given the issues around possible abuse and that having to be balanced. I think Advocate Pillay stated it very well, the balance that needs to be struck. I also support your recommendation, and maybe General Leshaba and Brigadier van Graan can make input into the proposed amendment to RICA, given the fact that they've struggled to obtain this exemption and over many, many years. Now, we've got to deal with that Constitutional Court judgment and the amendment, but maybe we can look at it broader. I don't know if we've got enough time, but Chair, this seems to have caused delays for many, many years. And so, Chair, I would support us looking, and maybe in our report on this issue, we could recommend that the department, together with the police, bring forward an amendment dealing with that constitutional as well as more pertinent issues, if that is possible. I don't know, but I would support your approach. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Engelberg.
Thank you, Mr. Chair. At this stage, I think I first need to take this to my caucus, because there's some issues that was raised by some of my caucus members to me. So I need to consult before.
Thank you very much. The DA reserves its position. Honorable Nieuwoudt-Droger.
Yes, thank you very much, Chair. I want to say that I agree with the proposals as you made them.
Thank you very much. So broadly, there is an agreement, and there is the reservation by the Democratic Alliance, which means at the next available time, I'm not sure whether when will the report be ready, Committee Secretary?
Morning, Chair, once again. Chair, we can ask that we draft the report and try and have it ready by next week, and maybe find a day to adopt the report if we still want to finalize this matter before this term ends. Because I think we're left with 2 weeks in this term in terms of next week, and the other week is oversight. So we might try and find time, maybe apply to get time, maybe an hour in the morning, and try and accept it. I'm just trying to think of it finding its way to the NHA.
No, what is important is that we must finalize it, and it should be the problem of the programming committee as to when are they programming it. Let's finalize it on our side. Because I think even the Joint Standing Committee on Intelligence is very nervous about us not finalizing this report. Let's finalize it on our side, and then the programming committee would find time, will find slots to program it.
Noted, Chair.
Can we, because I mean, it's just an adoption of the report. Can we maybe have a 30 minutes meeting on Tuesday? It will even be less than that, just the adoption of the report. And then we adopt the report. Will that be fine, Honorable Swart?
Chair, I apologize. I do need to just consult my colleague who is on the police committee as well. So I am in broad support, but I just need to just mention that as well. I wouldn't like to go past the person who's on the police committee as well. Thank you, Chair.
Yes. But what are you saying about the proposal for Tuesday?
No, Chair, I've got no reason why, but I don't think the National Assembly will be able to consider that given the pressure. But the meeting allow me to consult, and I don't have a problem with the consideration of the report. I will need to give you my view then. Thank you, Chair.
Thank you very much. Honorable Nieuwoudt-Droger.
Chairperson, Tuesday is a public holiday, so I'm not sure if we will be able to, but I would like to suggest maybe Monday evening or Wednesday evening after the sitting, possibly.
Yeah. Committee secretary is an important point because to work on a holiday.
Can you unpin Honorable Neodruchen, please?
To work on a public holiday would need an approval from the House Chair.
Sorry, Chair. I think maybe Wednesday morning, Chair, like we did the other day. It was a Thursday at 8 o'clock or at 8:30. We meet for 30 minutes and adopt the report Wednesday morning.
Wednesday morning.
I think Wednesday morning we'll do, Chair. We just
Thank
meet earlier.
Earlier.
Yes, around about 8, 8:30.
Which means members would need, those who are flying from other provinces would need to sleep in Cape Town so that they are able to connect at on Wednesday, let's say 9 o'clock or same time, 9:30, and then we can quickly deal with the report. And then it will be the problem of the programming committee as to when they program it. Is that in order, members?
Yes, Chair.
No objections. Honorable Jele? I think she has been kicked out. So I think that is all, members. Committee Secretary, would you want to update us on any logistical issues around the oversight visit?
No, Chair, we will send SMSs, Chair, because we're just awaiting final approval for today. We'll send members SMSs in terms of the information and also issue out the notice for next week.
Yes, and then when are you arriving? When is the Secretariat arriving in Joburg? And Honorable Yago, I don't see her here because we agreed that we must leave early so that we don't have to contest the road with animals at night.
Chair, as we've planned, Chair, we plan to arrive midday as we have agreed, Chair, around about 12 to 1, flying in the morning from this side of the Secretariat. But I think before the end of business today, Chair, we will send SMSs pertaining all this information to members. Because we're just getting vouchers and approvals, finalizing that today so that we can communicate a concrete final arrangements on our side.
Okay, and then also communicate with Honorables Horn and Honorable Breitenbach because we might have a problem when we have to go to what is this place? The other place, Northwest, after we have met with Judge President of Gauteng. I think we'll have one Kumbi for 8 people. So if they join us, we might need another car to go to Rustenburg.
Noted, Chair.
Thank you very much, members. Thank you very much.
Chair, sorry, Chair, I did note my formal apology. I'm very sorry. I'm just trying to shift things, but I did note my apology for the oversight. Thank you, Chair.
Thank you very much. Thank you to the department, the police, for your assistance. Thank you very much. And thank you to members and to everybody who's watching. Thank you very much. The meeting is now adjourned.